Good. So I'm happy to be with you today and to be able to discuss with you the question of gender equality in the context of civil and political rights. I'm happy to see the students here in the room, and I'm happy that we have those who can follow us online. And I hope to be able to see those who are online when the Q&A session begins. However, you can always interrupt me and you can pose questions and ask for maybe some additional explanations. My name is Tanasije Marinković. I teach constitutional law at the Faculty of Law, University of Belgrade. I also teach a couple of other subjects, and one of them is European human rights law. And I'm very happy to be on board with Professor Dragica Vojinović and other colleagues in this mission of also raising public awareness and bringing the topic of gender equality into our education. I won't go too much into these background information and details. There will be certainly place to discuss them in the context of this topic, the importance of education and the importance of public awareness when it comes to gender equality. As I said, you're free to ask me questions and interrupt me at any moment if there is need to for additional explanations or for some examples, and so on and so forth. So the topic of today's lecture is gender equality in the context of civil and political rights. That is taking gender equality seriously when it comes to civil and political rights. You may ask yourself whether actually there is any need to look at the human rights through the gender equality lenses. Isn't it maybe redundant, superfluous to question ourselves whether there is gender equality in human rights? Isn't it obvious that human rights presuppose equality as the first of all the rights? And isn't it obvious that equality implies gender equality? Well, it's really not like that, and I have to admit that we are still in that struggle of achieving gender equality, and achieving gender equality not on the paper but in practice, and also sometimes even in the paper. I would remind you that the modern constitutionalism and the modern fight for human rights started with one of these big declarations, such as the French Declaration of Rights of Man and Citizens, 1789. And that declaration does not apply to women. At that time, in that declaration, in as much as in the American Declaration of Independence and in many other big documents which preceded these declarations in the history of the, for example, English constitutionalism, we did fight for human rights, to use the modern language, but we did not imply women under that category. So what is interesting, and I invite you to take a look at the Declaration of Rights of Women, which was written by Olympia de Gouges in 1791. So one French woman decided to actually write a declaration on the rights of women, de la femme et de la citoyenne, of the woman and of the citizen, in a female form, in a female gender. So it's a very instructive document. It's a very instructive for nowadays, because when you look at it, you can see actually how much more there is still to overcome in the fight for gender equality. What she did was not to rewrite the declaration. She just corrected it to the point of bringing women into the fora, bringing women into the scene and equalizing men and women. And I would say also as a constitutionalist that in some aspects it's even more constitutional than it is more representative of what popular sovereignty should be and what equality should be than the declaration, the initial declaration itself. So our fight for equality didn't start with a fight for women's equality. At that stage, women were behind the scene. They were not visible at all. They were in the darkness. Even a century later, and here I just copied a passage of a constitutional textbook from the beginning of the 20th century on the Belgium constitutional law. And there we see that the author states that constitutional equality, not only that it doesn't condemn, but it orders the respect for the distinctions resulting from the nature of the things, from the life and social realities, including the sex, according to the author. So basically, in that first stage of our fight for the rights, the distinctions and differences between men and women were seen as a reason for treating them unequally, for treating them differently, but not to the advantage of women, just the opposite, to the contrary, to the disadvantage of women. So the differences were seen as an argument, as a reason, according to this author and many other authors. Because when we read those authors in the 19th century, when they claim the suffrage became universal, in a triumphant way, declaring the equality for everyone when it comes to political rights, we don't think at all of women. We just don't have women in our minds. We think of man. It became universal for man. And we see that it continued like that for many, many decades, even more than a century after the declaration, after the French Revolution, American Revolution, and other revolutions. This question, whether it makes sense to consider women as humans, was posed by Catherine McKinnon, one of the famous theorists. I believe you have mentioned her in a previous. So it's not shared. I'm sorry. Okay, I'm sorry. I have to share this. I share here. Is it shared now?
No, not yet.
Not yet, okay.
So you should click share and then select the already opened PowerPoint and then click share again.
I did click share.
Now you should have a list of all the open applications on the computer.
What was that? Ne, to je to. Oh yes, sure, I'm sorry. I'm just a bit, I had already so many classes. Yes, sure, thank you. Okay, I'm sorry for those who are following us online. It wasn't... Is it visible now, Nina?
Yes.
Okay,
yes,
great.
You can just full screen it maybe so it would be bigger.
Sure, this is what I wanted to do anyway. Thank you. So, in our own century, in 2006, Catherine McKinnon, one of the most famous feminists and feminist legal theorists, she posed a provocative question of whether women are human. So she says, if we measure the reality of women's situation in all its variety against the guarantees of the Universal Declaration, meaning the Universal Declaration of 1948, the United Nations Universal Declaration, not only do women not have the rights it guarantees, she also admits most of the world's men do not either. There is one T plus here. But it is hard to see in its vision of humanity a woman's face. Women need full human status in social reality. So what she is actually telling us, Catherine McKinnon, is that we don't need just equality in the paper, we need to see equality in practice. And what we see in many practices is that women are not treated, not only that they're not treated equally, they're not respected at all, and their dignity is gravely denied. It is so much actually relevant nowadays, the question of gender equality, in the context of basic elementary rights, that we needed to adopt within the Council of Europe in 2011 the so-called Istanbul Convention, that is the Convention for the protection on preventing and combating violence against women and domestic violence. So the respect for women's rights is not achieved. But when we speak of women's rights, we mean actually the gender equality, the equality between genders, and we mean the respect for civil and political rights, which are actually those basic rights. So later on, with the First World War and the advancement of the position of women, thanks to their participation in the First World War, and also due to the progressive ideas in that respect which came from the East, the Western countries decided actually to started introducing actually slowly women's rights and recognizing actually gender equality in their basic documents. Especially it happened after the Second World War. And again, it's also related to the participation of women in the Second World War as well, in the liberation movements. In that stage, we considered relationships between men and women as those which should be based on the principal tenets of liberalism, meaning that men and women should be treated equally, but that equality was seen mostly as formal equality on one side, and it also meant they should be treated identically, regardless of differences between them. Only later on we actually understood, and that is in the best way exemplified in the Istanbul Convention on preventing and combating violence against women, that recognition of equality should not be just formal and recognition of equality in terms of identical treatment, but also in terms of achieving equality in terms of opportunities and equality in results. So we see that it is important, exactly what Catherine McKinnon points out, that there is a need to actually have respect for women as humans in social reality. And in order to have that respect for equality in social reality, in order to have actually equality not only as formal, but equality in terms of equal opportunities and equality in terms of the results, we understand that we have to actually see the basic rights, so really the fundamental rights, sometimes in different lenses, in lenses which correspond to this goal of having equality in social reality, which would then presuppose, when it is needed, to take affirmative actions in order to improve the status of women and to reformulate certain elements of our legal systems in order to answer better, respond better to this need of equality as social reality. Not all civil and political rights are equally, in that sense, affected. Some of those which are particularly affected are right to life, prohibition of torture, inhuman and degrading treatment, respect for private life, freedom of thought, conscience and religion, right to marry, freedom of expression, and right to free elections. So these are not all civil and political rights, but those which are particularly affected in the context of the achievement of this goal of gender equality. Istanbul Convention tries to actually respond to the question of violence in a comprehensive way. And it defines violence not only as what we would usually see as a violent action, as a violent act, physical violence, or sexual violence. It also clearly stipulates that violence is psychological, can be also psychological, and that it can also manifest itself as economic hampering of women. So violence can take different forms, and we have to recognize it in its totality, so as to be able to respond to it in a most effective and efficient way. If we want to achieve equality in practice, in social reality, then we have to strive for those legal measures which would actually contribute to the effective implementation of the conventions and other legal documents. Istanbul Convention does not, in itself, provide for a mechanism of individual complaints. So there is no possibility to file a complaint and to seek before the grevy the kind of redress that we would find before the European Court of Human Rights. And so many actually of the principles contained in the Istanbul Convention are actually derived from the experience of other monitoring bodies, either those which are established under the UN documents or those which are established by the European Court of Human Rights. The comprehensive approach to eradicating violence, which particularly affects Article 2, 3, but also 8 of the European Convention, and as well Article 12, because forced marriages are also seen as a form of violence. We have to understand that the state has to take different types of measures in order to fight against it. Those measures are, some are of a preventive nature, and some are of repressive nature. The state has to adopt, first of all, policies in order to, as we said from the beginning, at the beginning of this lecture, in order to raise awareness about what the violence is, how it can manifest, and how we should behave in order to avoid it. Those preventive measures also concern those policies which are intended to prevent the possible violence, also concern introduction of these types of programs into educational systems. And we are conducting one of those programs at the law faculty, which is very important because of the the students of the law faculties, but those who follow our school also come from other professional backgrounds. Nevertheless, the university level of education is very important. The law faculties are very important because it is here that future judges, prosecutors, so to be attorneys, are educated. And they are those who, or even MPs and those who are working in the public administration, and those who are responsible on the side of the state to actually act to prevent or repressively act when it is needed to react to violence. The role of media is also stressed in the Istanbul Convention, and the role of other private actors, non-governmental organizations, the civic society in general, including religious organizations, churches and religious communities. What we have seen previously also in the case law of the European Court of Human Rights is that when an act of violence takes place, the state has to react. First of all, the state has an obligation, negative obligation of not endangering anyone's life. So there is a negative obligation on the side of the state, not only when it comes to right to life, but all other types of actions which are considered as violence, and depriving someone of life, or physically hurting someone, psychologically hurting someone. These are all different types of violences, and the state has an obligation to refrain from taking those actions. But state also has obligation to act positively. So in that sense, the Istanbul Convention speaks not only of policies and preventions, but also of prosecution and of punishment. So those who have committed the acts of violence, and here we refer also to non-state actors, individuals, private entities, so natural and legal entities, they all have to be prosecuted for the acts of violence. State has an obligation to prosecute those individuals. So the state has a positive obligation to protect, which is something else. It means that state, whenever it is in a position to have information about someone whose life is endangered, has an obligation to take necessary measures to protect those individuals. So it comes even before the prosecution. It becomes even before this repressive action. It implies the obligation on the side of the state to protect those individuals when it has information which are relevant and which concern the physical integrity and other forms of integrity, psychological integrity of individuals, especially women, according to the Istanbul Convention. Yes, can you just state your name and take the floor?
My name is Dimitri Parizanovic, and I want to ask you, what is your stance on abortion? Because in accordance with the Article 2, the right of life, since it deprives one of having a future life, basically.
Okay. Thank you, Dimitri. Yeah. Thank you, Dimitri. Yes, the question of abortion is a question which comes in the fore of the question of the right to life. European Convention and international documents do not take a stance on that point. they don't decide when the life begins and when the life ends. So the question of abortion is relevant in the sense of protection of the right of fetus. So at what point do we count that fetus can be considered as a living being, and at what point do we consider that there is no right to abortion because abortion would imply taking someone's life? Yes, Dimitri.
Yes, but we also learned in the book which you, how do I say, in the book of the constitutional law, that basically Serbia also allows that you can have abortions later, like over 2 or 3 months in certain cases.
Yes. So I was speaking of international documents, because the questions of abortion or questions of euthanasia, which concerns the problem of the ending of the life and when the life ends, and whether we can take measures to, whether a person can decide on the ending of his or her life, are questions which are extremely sensitive, and they're related to the question of morals. And the questions of morals are very much, again, related to the national communities, national, not international, but national communities, to the nation states, because states have different customs, different religions. I mean, the majoritarian customs and majoritarian religions are different, and in that sense, in international fora, we don't take position in that respect. Our legislation allows for the abortion, and it also allows for the abortion which is not considered as a medical abortion, in terms of those situations which when abortion is necessary in order to protect the life of a mother. And in that sense, I don't have anything else to add to what our legislation in that sense prescribes. So it does allow, I think, from the I think up to the 10th week actually of pregnancy, it allows for the abortion. So we see that question evolves, it changes. It also is a question which is related to the issue of physical integrity of women, and to also their right to decide on their physical integrity. There are many other things which actually also are relevant in the context of physical integrity of women, such as also genital mutilation, which is allowed in some societies, under some religions and some customs. Also the question of the different obstetric practices in terms of gynecological interventions, and our awareness in that respect is manifested in the fact that we are more and more concerned with the way the women are treated actually in those kind of situations, and that we need to also provide to them treatments which are the least harmful to them physically. Dimitri, you have, by raising the abortion, you have raised another important set of questions which are related to the freedom of thought, conscience, and religion as well, as one of civil rights. It brings into the fore actually the importance of customs and religion in the definition of human rights, because we see that cultures and religion pretty much define our way of understanding the role and position of women in modern societies. What we consider by custom there are actually not only customs but cultures. So custom is actually only one possible way of defining culture. There are other ways of possible ways of defining culture. So what's going on?
Cacophonia. All the time we had cacophony because
Okay,
of
microphony.
somebody.
Yeah.
No, but somebody who is online was unmuted. And now I prevent her. So no, I did it.
You muted.
Excuse me.
Yeah, sure.
You muted the speaker, not her.
You muted Tanasije, not her.
A pa onda popravi kako, pa ne idemo dalje.
Excuse me?
Sve vreme je čujemo, a ne možemo dalje.
A napisala je Nina na chatu da se vidi kompjuter.
Šta se
Ne znam da vidim tu, ne mogu odavde da vidim.
Da se vidi tu, ali izgleda da ne gleda kompjuter.
talasove, jel?
To je trebalo odmah da uradiš. I da se vidi chat, ima pitanja u chatu. Ne mogu odavde, znaš, ne mogu da priđem, smetam
Aha,
ti.
dobro. Ne, mislim, okej. So we see, for example, that controversy when it comes to freedom of thought, conscience, and religion. Religion is a system of belief, a normative system which creates identity of many people, including many women. And at the same time, there are religions which are, through their customs, which they prescribe or which they imply, actually impose inequalities between men and women. And that creates a terrible, so to say, a split in the societies and in the individuals as well, in terms of obeying the prescriptions of the religion on one side, and on the other side, respecting the dignity of women. We saw it recently with the question of Islamic veils, for example. To what extent, on one side, there are interpretations of Quran which call for the use of veils, and even those veils which, like burqas, which totally conceal the face of women, on one side, and we see on the other side how much it is harmful to the equality, equal enjoyment of many of the rights of women in the society, of those women especially who are in a situation that they cannot open up their faces and they cannot actually establish the communication with other people. So in a way, the veils prevent them from communicating with others, prevent them from establishing social relationships with others, and in that sense prevent them from being treated with dignity. Because treating people equally implies actually respect for their dignity. So, or the question of free elections, the need to actually establish female quotas as a way to remedy for for the not sufficient presence of women in the public sphere, because for many centuries women were not allowed to participate in public life. They were actually relegated to the house and domestic functions, looking after the family, and providing, in that sense, help to the husband. Women did not participate in public life, and even nowadays we don't have in many societies sufficient women participating in the public lives. So we realized that after this big wave of recognizing women's right to vote in many constitutions after the Second World War, we realized that many decades afterwards, women were still not present in the parliaments, and so we needed to introduce quotas. we need to introduce suffrage female quotas in order to stimulate the presence of women in the parliaments. And that doesn't go so easily. Simply, constitutions proclaim equality of men and women, and they don't proclaim affirmative action in that respect. So those conservative sides of the societies, they brought actions before constitutional courts challenging those quotas. So there, after the first fight for the female suffrage, came another not only political but juridico-political battle for the recognition, for the maintenance of those quotas in the legislation, simply because constitutions did not see equality as a possibility for treating differently to the advantage of women. And as a result, many constitutions had to be changed in order to introduce quotas. So we see that the new, so to say, the present understanding of equality implies, as I said, affirmative action. It applies, it takes into account actually differences. It does not deny the differences in terms of treating men and women identically, and it doesn't take differences as an argument, as we have seen, to treat men and women differently to the disadvantage of women. No, it takes the differences when it is legitimate in order to improve the position of women by different measures of affirmative action. This also includes, when it is needed, the regulation of freedom of expression. Civil and political rights, the freedom of expression is actually in the heart of both civil and political rights. We tend to see it primarily as a political right, because it is very much important for the advancement of democracy and for the fight against corruption. But freedom of expression is also very much important for the personal achievement of each and every individual. It is important for the artistic expression. It is important for all forms of individual expressions through which identity of persons are expressed, are manifested. It's also, of course, relevant for our academic work. However, when it comes to human dignity, we realize the necessity to act in a way to protect the dignity by recognizing that not every type of speech is allowed and that not every type of speech is considered as legitimate. So when it comes to sexist speech, when it comes to misogynic speech, when it comes to speech where women are debased, exactly because of their sex and because of their gender, that language has to be prosecuted, and in that sense, we also see the repressive action of the state. Yes.
So it's viral on social media about gender pronouns. Should we look at it like a violation of human rights, or it's something simply wrong to force other people?
Can you just tell us first your name and what you meant by gender pronouns? I didn't understand that part.
Nemanja.
Nemanja?
For male, he, him, or for female,
For
she,
using
her,
using
and,
of gender, yeah?
And for non-binary people and some made-up words like
Yeah.
they, them, ze, them, and so on.
Yes, it's something which is presently very actual in our society as well. We have a legislation which obliges us to. It is not. Some legislation is in that respect already in force. And when it comes to the law on the gender-sensitive language, it will enter into force. It is important to treat. It is important to treat individuals with respect. Here we speak of gender equality. We could, of course, speak of other equalities. Gender equality and equality in general protects dignity. It implies, among many things, that we should always take an individual as an aim and not as an object. So you take that person as an aim in terms of how that person sees himself or herself. Maybe some, for example, professors, she professors, would not be insulted to be called he professors. Okay, I use this terminology in English because English is in that sense a gender neutral language, contrary to our language, to Serbian language. So it is true that we would say profesorka for she professor and professor for he professor. I would personally be insulted if someone calls me profesorka, she professor. And I'm sure that you and many other male colleagues present here would be insulted to be called studentkinja. So I think that we need to, the principle, the first principle is that we should treat everyone with respect and with dignity. It means to call that person in a way in which he or she wants to be called, wants to be treated. That is when we are addressing ourselves to the others, and sometimes we know what the others expect and what the others do not expect, what they want, what they don't want. Sometimes we do know, sometimes we don't know. When we don't know, we are obliged to respect social conventions. We are obliged to behave in respect with respect to what are the established social conventions. And language is, by definition, a question of convention. It is absolutely a matter of convention. Just like gender is a social construct, the language which we use, the way we communicate, it's a social construct. So the terminology which was not commonly accepted 10, 20, 30 years or more years ago is now becoming more and more accepted. And we need to follow those trends. So the second principle is that we should follow the social conventions, and those are linguistic conventions as well. The third principle would be that we do need to improve our social conventions, including linguistic conventions, when they are not respecting the gender-sensitive, the use of the gender-sensitive language, which means that we should work more and more on adapting our words to the gender-sensitive language. Because gender equality, as I said, implies that I would not like to be treated as profesorka, as she professor. And so if you don't want to be treated as a studentkinja, as she student, then I'm sure that it concerns other professions. And if there is need for gender-sensitive language in other domains, I don't see reason why we should not go further in that direction. So we need to improve our conventions in order to reach the necessary standard of gender equality, as I said, so that women are treated equally, not only in the paper but also in practice. Okay, does it answer your question?
Yes, thank you.
You're welcome. I heard that there are questions, comments. I would actually prefer if there are comments which I can't see right now, if someone can help me with opening that bar. And I would actually appreciate if you can, here are more. Those who have comments or questions, I would appreciate if you can pose them orally, so we can hear each other rather than to read them. Because does anyone who is participating online would like to take the floor? There is actually a communication here between the students themselves. I would appreciate if there are comments or questions to be posed orally. If not, those who are in the room, if they want to pose a question, they're more than welcome to do it.
Yes, my question is that there are instances of cyberbullying against women. So we have seen some instances like particularly during the elections, if there is a female candidate, then people try to defame her or maybe lower her image in the eyes of other people. And these instances have now become very common. And more during office hours, certain remarks against women. Now, how can we stop all these abuses?
I'm sorry, can you just state your name again, and can you repeat your question, because I couldn't, there was a problem in connection.
Yes. So my name is Prof. Singh. I'm from India.
Hello.
And my question to you is that when we talk about fundamental right of freedom of speech and expression, so this fundamental right of freedom of speech and expression does not exist verbally only. It also exists on the online platforms.
Yes.
And we have seen a lot of times during the elections when there is a female candidate contesting, so there are certain remarks against those females, and they are particularly gender specific. Now, how to stop such abuses?
Yeah. Thank you so much for your question. It is indeed one of the problems that we are facing nowadays, cyberbullying, and also other cases of hate speech online, in online platforms. Generally, that sphere is not sufficiently regulated. It is becoming more and more regulated, actually, through European Union. When it comes to European Union, through its legislative acts, and even before that, European Court of Human Rights started establishing some of the principles in the Delphi case, which concerned the hate speech on the internet platforms, by which it imposed on the providers an obligation to follow the speech which is being spread on those platforms, and to sanction that speech by preventing it from being published, or by actually withdrawing it when it is published. Now, that is again a repressive way to react. There is cyberbullying, as you said, in the context of elections. There is also cyberbullying of women in other contexts, and not only in the context of elections. I believe we have to work more on the raising of the awareness, and that raising of the awareness has to take place. I didn't finish my thought from the middle of the class. I pointed out the importance of university education. I pointed out the importance of legal education, but these things, when it comes to the society, they have to be actually introduced as programs already on the level of elementary and pre-elementary level of education, secondary as well. Of course, it has to be adapted to the concrete age of those children. The raising of the awareness of gender equality, and also raising of the of understanding what hurts the other, because sometimes we don't have intention to hurt, and we do hurt because we don't actually understand fully what is how do the person on the other side feels about what we are saying. So education is the most important. Education is the most important form of socialization. Other forms of socialization are also very important. Media. We need to have a media legislation which establishes clear sanctions, and not only criminal sanctions, but also administrative measures for those media which disrespect gender equality and which use sexist and misogynic language. And the role of political parties and religious communities. We have seen recently a statement of our patriarch in Serbia, in which he the context is not fully clear, but a video clip was published on social media, in which he named called an unnamed woman. He used a very debasing language by calling her wretched and a poor woman, using the Serbian appropriate gender forms, jadnica and bednica. So it's extremely saddening to see someone at such a high social position, occupying the highest place in the Serbian Orthodox Church, spreading a misogynic language. It was not at all helpful. The statement, which was later on published by the church itself, in which we were explained that his speech was not addressed to all the women, but to one particular woman, without precising who that woman is, nor it is important at all to know who that woman is. The language itself was extremely offensive, debasing. To say for someone that she is wretched and miserable doesn't mean that she is poor materialistically, economically, but that she is morally poor, and when someone is morally poor, that person is not morally worthy. So you see, there is unfortunately lots of misogynic language which comes from the very high places, and we have to fight against that kind of speech. The higher position we occupy in a society, the bigger responsibility for all of us is to fight against that kind of language. So, dear colleague from India, there are many ways to fight it, and the action really has to be all comprehensive if we want to have gender equality achieved. And we see that when it comes to human dignity, we have seen it in Belgrade recently, how violence can go beyond verbal and become actually physical. So in that sense, we need to be very, very, very responsible with the language we are using. Okay, I see that Nina has raised the hand. Nina.
I'll be brief. I know you have to take a break now, but I just have to object to this qualification of the statement of the patriarchs as misogynistic because it was very heavily taken out of context. Yes, it was insulting. We could raise the question whether it is appropriate for the head of a church to speak of anyone in an insulting language, though then again, we could also very much raise the question whether it was appropriate for someone to record and publish something that was said informally in private atmosphere. Yeah. I'm sure there's hardly anyone here who hasn't called someone we dislike or disapprove of an idiot or a miserable person or something like that in the heat of the moment, in private circumstances. And yes, we'd all be embarrassed if such a recording made its way to the public, but it was directed against a single person. If I was now caught speaking of some male idiot, miserable man, etc., would that be misandric language on my part, regardless of the context?
It would be, Nina, and I'm sorry, but yes, you're right, it was insulting, and it was not helpful at all that we learned that it concerned one woman, because every woman enjoys it, so equality for everyone, every single person, including every single woman. And yes, it was not in his bedroom speaking to himself, but it was at a public event. And yes, recording of these things may be problematic, but when it comes to high-profile figures as he is, and taking into account that, as I said, he was not taken in his private rooms, but he was at a public event, from the point of view of his right to privacy, he has no argument to raise. On the other side, when it comes to his high social position, we have every right to learn about his statement and to hear his actually apology to this woman. And this didn't happen. He was obliged after it happened, so we can argue, and I'm telling you that there is no way to defend the problem of publishing of that video clip in the context of who he is and where it was stated. And not only that there is no problem to publish it, but there is a problem of him not apologizing to that person, or without again naming, because it would be good not to name her anyway, but without apologizing for using that strong and heavy language. So I'm sure that if it happened to you in a classroom, that you in a heat, as you say, of a discussion, use the strong language of someone, although I don't have impression that he was in a heat of a discussion. But if it happened to someone to be in a heat of a discussion and to use a strong language, strong inappropriate language, which then becomes viral, I'm sure that you or I would definitely, if it happened, I would excuse myself for using that kind of language which could have offended anyone. And I'm sure that you would agree that our position as university professors is important, but his position is even more important. And in that sense, obligation is bigger.
I agree with that. I just believe that this issue was more political and much less gender-related, and as that it could have happened just the same had it been regarding a male person.
I'm also sure it was political. I agree with you. It was political. It was not a coincidence that it came out, but it's out of the context of our lecture today on this topic. Nevertheless, it doesn't change the fact that that was inappropriate language and that we all have to react to that kind of language and that we have to condemn it. Okay. Yes. Is there someone else online?
Yes. The most recent debate which is happening right now is when some person posts something on digital platforms, is it the liability of intermediaries or is it the liability of person only? Why intermediaries are not being regulated? Why they are not using AI to condemn all such languages? Why still people can post such languages on social media platforms? Why there is no regulation? So who owes the onus and responsibility? Is the person who is posting that, or is the intermediary which is not stopping that person from posting such comments?
Yeah. They're both liable, but sometimes when it comes to those who are posting, we can't always know who those persons are. So there is that kind of problem, and this is why the intermediaries, the role of the intermediaries becomes even more important. I would tell you that this is a very much relevant question. The under-regulation of hate speech on internet and misogynic speech as well in that sense. One of the reasons why it is not sufficiently regulated is because of the high value of free speech. So there is that aspect that free speech is so much highly valued. As I said during my lecture, for various purposes, including protection of democracy, fight against corruption, development of individual aspirations and affinities and professional developments, that sometimes it is not easy to draw a line between a language which is a way of artistic expression, and there has been a number of instances of different singers using a language that you would call we would call vulgar, but which is also in their way, this is how they portrayed it. This is their way of also drawing attention to the inequalities in the society. So sometimes it's not easy to draw a line between, first of all, artistic expression, which is offensive to the point of the need to prohibit it, and on the other side, different forms of artistic expression actually sometimes, exactly by being shocking and disturbing, draw our attention to some inequalities in a better way than a polite language. So there is that problem of language in general, and we are facing it in this context as well. Okay, I see that.
Professor.
Yes. Sure.
Problem can be if I from India, I'm making some comments against a person in Serbia.
Yes.
So it will be difficult for the courts to have jurisdiction and to punish those persons which are from different jurisdiction. So extraterritorial jurisdiction, I think digital sovereignty becomes very important in such cases.
Indeed.
And we see a lot of cases where fake news is being spread from different countries. And in such cases, it is very difficult because everyone is using these online platforms. So this becomes a problem, and it is very difficult to solve this problem nowadays. And I would like to thank University of Belgrade for organizing such an important course. And thank you, Professor, for...
Thank you so much for your comments. They're very much pertinent. I'm myself very much interested in these topics related to the regulation of the hate speech on the internet. But now we have also a third lecture, my dear colleague Ivana Krstic. However, we will make a break, a promised break of 15 minutes for everyone. Thank you, and looking forward to seeing you in other sessions of this course.